Hi, I'm Debbie Moraes, and this is Legal Matters, the program designed to address the critical issues facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics, from finance to family law. Today we'll be discussing more about family law. In our last segment, we discussed the federal and local and state court system, specifically municipal and district court judges, and of course, who better than our two guests to handle that, Jackie Grasso and David Bazaar from Audette, Bazaar, Cordeiro Grasso law firm in East Providence. While we were discussing those topics, we always do ask the viewers to email us with various questions, and when we were talking about judges, one of the questions was, are you ready? Mm-hmm. What is the difference between judges and a magistrate, and what's the difference in their backgrounds and how they're appointed? Jackie, David?
Well, let's talk about it together, yes. And let's talk about it. There's both a federal and a state court system, as we discussed last time. The state court system, the difference primarily between magistrates and judges is how they're appointed. Judges are people, lawyers, who have gone through the Judicial Nominating Committee or Commission, which vets out applicants for qualifications and then submits 3 to 5 names to the governor for selection to a particular seat. Magistrates are appointed by the chief judge of the particular court and then confirmed by the Senate. Both of judges and magistrates need to be confirmed by the Senate, but the process of selecting them is a little different. And then talk a little bit about the jurisdiction.
Magistrates have limited jurisdiction, meaning they cannot hear trials. There are certain areas in their particular court that they are not empowered to make decisions about. So, for instance, we have magistrates in family court that handle child support matters. We have magistrates that handle restraining orders, so the domestic abuse calendar. But specifically, they're not allowed to handle trials. And as well, magistrates serve at the pleasure of the chief judge, so there is, in some cases, there's not a term for them. Like regular judges, they serve at a lifetime tenure.
That's the other major difference. Judges are a lifetime appointment in Rhode Island. Magistrates, at best, would be a 10-year term.
Depending on the court.
On the court and what they're selected under the process that they've been
Now, you have magistrates
chosen.
in federal court as well, so
Right.
you have a different
and again,
selection process.
The process is different, and the big difference in terms of jurisdiction, as we were just talking about, is any decision by a magistrate in federal court, magistrate judge as they're called, is appealable to the district court judge for a review or decision. So the magistrate really primarily helps in the process, listening to motions, helping to pick juries in some cases if it's not a criminal case, but most of what they do is to make recommendations that then the judge in the district can accept or reject.
Well, while we had the overview of the federal and focused on the district and municipal, because of course you two are seated judges right now, you are in East Greenwich and Jackie in Bristol. You talk a little bit about the jurisdiction. What about someone's background? You went to law school. What are some of the backgrounds of a magistrate?
Oh, it's the same thing. You have to be an attorney who's admitted to practice in the state in which you're seeking an appointment, and you have to be an attorney in good standing as well.
Although there may be some question as to whether or not a Supreme Court justice has to be an attorney.
That's correct. Yeah,
that's an interesting
old Lincoln laws.
Yeah. The federal court system obviously flows from the Constitution, so that would be an interesting question there. And we talked about being municipal court judges. There is a requirement in East Greenwich, as I recall the city ordinance and the statute that created the court, that you be a East Greenwich resident with at least 5 years membership in the Rhode Island Bar. Most other state and federal judgeships don't have a number of year requirement of being a lawyer, and like I said, in some instances may not even have to be a lawyer. But usually the magistrate requirement's the same as a judgeship requirement.
Okay, fair enough. Well, onward. So today our topic is going to be about really related to family court, and specifically things like children, child support, child custody. Obviously, that's always a very contentious kind of issue. What happens if two divorcing adults decide that they can't decide who's going to take Johnny? What happens?
If you have a custody dispute in a divorce, the first thing the court would do is ask that a guardian ad litem be appointed. And a guardian ad litem could be a social worker, a psychologist. In most cases in Rhode Island, they're usually lawyers. That person is there to represent the interests of the child, because the standard in every case involving a child, no matter what the issue is, what's in the best interest of the child. So the guardian ad litem is also the voice of the child, the minor children or child or children, and an extension of the court, because the guardian ad litem is empowered to speak with outside agencies or outside physicians, anybody that's affected the child's life, so they can actually get records from schools, they can get medical records, they're empowered from the order of the court to get any background information that would be necessary to aid the court in making a decision as to which parent should have placement.
Let me give you a little historical perspective to that. I started as an attorney in 1983. Guardian ad litems weren't used as often then as they are today. In fact,
Why is that?
Well, it just wasn't a practice that had been started or accepted in Rhode Island. There's a cost to using guardians ad litem because they need to be paid. So what would happen back then is the court system often would just involve the two attorneys trying to work something out, which if you could do that, obviously it's in everyone's best interest. If not, the children, if they were old enough, and there's no rule, but rule of thumb, if they're a 12-year-old, 13-year-old child that's fairly mature, the court back then would let the children come into the chambers and speak to the judge. Judges have gotten away from wanting to do that because more than just speaking to the child, as Jackie was saying, is involved in determining what's in the child's best interest. It's not what the child wants necessarily, it's what's in the child's best interest. So the use of guardian ad litems has increased so that the court can get both the input of the child without the child having to speak directly to the judge, which can be intimidating, and the ability for the guardian to get other records that might be relevant. Then the other change that's really developed over that time is use of mediation, which we've talked about in the past.
It would, well, I think that that's probably something we can save, because I assume that somewhere along the line, when it comes time to talking about visitation, custody, how much money and the rest, it wouldn't it be very nice if people could do that amicably rather than having it be so contentious as in...
There's a process that's practiced in Massachusetts called collaborative law. It's not utilized that much in Rhode Island. Essentially what that is, to put it simply, it's two people involved in a lawsuit agree to collaborate outside of the court. So they agree that they're not going to litigate the case in court. It's going to be handled outside of court. It's almost like mediation, except you have your own attorneys present. It's not that much utilized in Rhode Island, but it is utilized somewhat in Massachusetts, and it's an area, I think, a growing area of law that it would be very beneficial in the future.
Yeah, the difficulty with the type of practice that we have in Rhode Island is it's contentious enough already in family court, especially when you're talking about children in custody and those types of fights. So it's hard to take what we do, which is have attorneys who are supposed to be representing vigorously their clients and say, step back a little bit and be more collaborative in your approach and take this new type of system that Massachusetts is using and use it. I think since it's already contentious enough, it's a good idea for us to start moving towards that, moving towards the mediations which we do already use. Although, as we talked about in our mediation segments that we've had before, mediation in Superior Court is different in many ways from the way we do it in family court, because lawyers participate in Superior Court mediations. They don't participate, most cases, in family court mediations. It's just the parties.